Welcome, everybody. My name is Wendy Murphy. I am here as a director of the Women's and Children's Advocacy Project at New England Law Boston. So I'm here at New England Law Boston, but I want to be clear at the outset. None of the cases we're going to talk about are endorsed or supported or promoted or at all part of the New England Law Boston administration. We filed a new lawsuit. The new lawsuit has been filed primarily on behalf of a team that I work with, a national organization called Equal Means Equal. Equal Means Equal has been one of the leaders in the fight for women's equality for a very long time. I've been working with them for a very long time. They are a nonprofit organization, and I want to say they date back to before 2000. I think they started in around 2009. Maybe I'm off by a little, but anyway, they've been around for a long time. And the case that was filed in Massachusetts federal court against this current administration. And it makes the argument that it is unconstitutional for women to be denied the opportunity to register for selective service. For those of you who don't know what selective service is, it is euphemistically called the draft. I should say selective service is a euphemism for the draft, but it is called selective service in the sense that you must register. So I don't think that we're not giving you the chance to select or not, but the selective service language applies only to men. So there's a federal law called the Military Selective Service Act, MSSA. It specifically mandates that men register for the draft, and it specifically forbids women to register for the draft. Now, why is this interesting? Well, we haven't had a draft since 1973, and I don't think anyone thinks we're going to have one anytime soon. But for women who want equality, this is a glaring example of what's allowed under intermediate scrutiny. With intermediate scrutiny, you can have a law that says men can do this, women cannot. We don't have a lot of laws like that right now, but this is one of the examples. And there's one Supreme Court decision on point as to whether it's constitutional to deny women the right to register for the draft. It dates back many years ago. And the Supreme Court said, since women cannot fight in combat on the front lines in the military, it's okay to forbid them to register for selective service. Well, that changed about 10 years ago. Women now do fight in the front lines in all branches of the military. They are giving their lives. They are sacrificing their lives, fighting for their country, standing tall for American democracy, just the same way men are. For 10 years, this has been the reality for women in the military, and yet they are still forbidden to register for selective service. Our lawsuit says that's not acceptable. Not only should women be treated the same when it comes to something as important as who gets to fight for their country, but it's about time the courts announced that there's no longer any justification for treating women differently under intermediate scrutiny. It's time to give women strict scrutiny. So the case we filed basically is an attempt to do exactly that, to elevate women to strict scrutiny and to point out that this is a glaring example of how facially discriminatory some laws are. Now, you might be opposed to the draft. You might think, isn't that silly? Why would women want to sign up for the draft? It's not about the draft. It's about equality, and it's about making sure that the messages that come from our government don't establish women as different and worse people, different people entitled to worse rights. That's the history of our country, keeping women separate and unequal. It's 2025, and it's time to fix that. So most important thing I can tell you about the case is the issue is going to the United States Supreme Court probably in 2026. I say that because there's another case on this very issue pending in the Ninth Circuit, which is in the District of California. That case was filed by a man named Victor Valame. when he turned 18, because again, men are mandated to register when they turn 18. Women are forbidden to register at any age. A man filed a lawsuit then against President Biden saying, this law discriminates against me because I'm a male and I feel offended and hurt and discriminated against, that women don't have to register and I do. Now, think what you will about whether a man should have the right to file such a lawsuit. The courts have agreed that men do have a right to be heard on the sex discriminatory nature of the law. But his argument is really about discrimination against men. Our lawsuit is about equal rights for women. It's not just a different type of framing. It's not just a different tone. It is literally a different way to present the issue because the result will be dramatically different. Victor Valame's case is headed to the Supreme Court. I don't think it's right, and I don't think anybody would agree that a men's rights discrimination against men case ought to be the vehicle through which the United States Supreme Court decides the constitutional status of women.